Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today may be the day I earn your subscription. For today's case, we're dealing with whether or not a public university can force its students to get the COVID shot. This is a case of Ryan Klassen versus the trustees of Indiana University. In this case, Indiana University, which is a government school, is requiring students to get the COVID shot, or in the alternative, mask up and have to be tested bi-weekly. So we're going to read this case and see what the law has to say. Let's get started with this. Starting next semester, all students at Indiana University must be vaccinated against COVID-19 unless they are exempt for religious or medical reasons. Exempt students must wear masks and be tested for the disease twice a week, in which case we're not sure exactly what happens, but okay. 8 students contend in this suit these conditions violate the due process clause of the 14th Amendment. So they're saying, look, by forcing to be vaccinated, you are trying to take away our right of autonomy. And this is a violation of our substantive due process rights. Okay, let's see. Given Jacobson v. Massachusetts, which is everyone's favorite case on this case, U.S. Supreme Court from 1905, which holds a state may require all members of the public to be vaccinated against smallpox, there can't be a constitutional problem with vaccination against COVID. All right, so right away, I have to take exception with the Court of Appeals. They say that Jacobson says that all adults have to be vaccinated. Well, that's not exactly quite true, because if you didn't get vaccinated, you would be fined $5. In 1905 dollars, which I looked it up, is roughly the equivalent of $150 today. So get the shot for smallpox, or get whatever it is for the smallpox, or pay $150 in modern money. So it wasn't exactly everyone has to get the shot. It was get the shot or give us some money. So I don't think, that's not quite right. Plaintiffs invoke substantive due process under Washington v. Glucksberg and other decisions. This argument depends on the existence of a fundamental right ingrained in the American legal tradition. Yet Jacobson, which sustained a criminal conviction for refusing to be vaccinated, shows the plaintiffs lack such a right. Again, calling it a criminal conviction is slightly misleading, because the relevant statute said the only possible penalty was the $5 fine, which is $150 today. So, I guess it was criminal in nature, but it was only money. So I don't know that quite is the same thing as here. It's like, you could be convicted, but it wasn't that big a deal. Give us $150 in modern money. So, okay. And this case is easier than Jacobson for the university for 2 reasons. First, Jacobson sustained a vaccination requirement that lacked an exception for adults. The exception would be, by the way, pay us money. But Indiana University has exceptions for persons who declare vaccinations incompatible with religious beliefs and persons for whom vaccination is medically contraindicated. The problems may arise when a state refuses to make accommodations that are therefore not present in this case. Indeed, 6 of these 8 plaintiffs have a religious exemption, and a 7th is eligible. These plaintiffs just need to wear a mask and be tested, requirements that are not constitutionally problematic. So, okay, so they can force you to wear a mask and force you to be tested twice a week, every week, and wear a mask, which, in no way is going to make you succumb to peer pressure and stuff. So, Second, Indiana does not require every adult member of the public to be vaccinated, as Massachusetts did in Jacobson. Vaccination is instead a condition of attending Indiana University. People who do not want to be vaccinated may go elsewhere. Many universities require vaccination, but many others do not. Plaintiffs have ample educational opportunities. So, you can just transfer to a different university. Okay. Each university may decide what is necessary to keep other students safe in congregate settings. Health exams and vaccinations against other disease are common requirements of higher education. That much is true. Vaccination protects not only the vaccinated persons, but also those who come in contact with them at a university. Close contact is inevitable. Okay, we assume with the plaintiffs that they have a right to bodily integrity. Yeah, I seem to remember something about my body, my choice, but I guess that isn't in this case for some reason. They also have the right to hold property, yet they or their parents must surrender property to attend any university. Yeah, I mean, yes. Undergraduate must part with at least $11,000 a year, even though Indiana could not summarily confiscate that sum from residents. Yeah, I mean, they do require you to give money to attend the university. So, yeah, but that's kind of part of a contractual bargain. Uh, it's not exactly, yeah, I don't think it's quite on point. If conditions of higher education may include surrendering property, which I'd like to take note is not really in the same category as giving up your own bodily autonomy and treating them as exactly the same is a little bit off point. And following instructions about what to read and write, because there will be classrooms and they may require them to read and write stuff. It's hard to see a greater problem with medical conditions that help all students stay safe while learning. A university will have trouble operating when each student fears that everyone else may be spreading disease. Few people want to return to remote education. We do not think the Constitution forces the distance learning approach on a university that believes vaccinations or masks and frequent testing will make in-person operations safe enough. The motion for the injunction pending appeal is denied. Thus, that brings us to the end of the case of Ryan Klassen versus trustees of Indiana University. In this case, we learn that Indiana University, like many other universities and colleges, are requiring their students to be vaccinated or mask up and get tested twice a week, which I'm sure will in no way, succumb people to peer pressure. And if those students really have a medical issue, will require them presumably to have to disclose their medical issue every time they're confronted, which will be, more than a little annoying. So, yeah, so we are going to essentially badge the people, or anti-badge them, I guess. And no, we're badging them because we're making them wear a mask. So we're making them wear the star on their clothing, as it were. Fun. And, yeah, so the Court of Appeals for the Seventh Circuit somewhat misstates what Jacobson decided, somewhat misstates its holding, somewhat overlooks the difference between bodily integrity and property, and says that this mandate is fine. So, that's the law, at least in the Seventh Circuit, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye. Internet commentator says, did you really just compare the Star of David forced upon Jews during Nazi Germany to the COVID-19 vaccinations being required? Not to the COVID-19 vaccines themselves, but to the mask. To the mask, because it is it's an external symbol that reflects a status, right? If you're not vaccinated, you have to wear a mask, right? So because of your status, you are being forced to externally display a representation of your status. So I was comparing the masking requirement to the Star of David because both cases, the government was requiring you to identify yourself as a member of a particular group. So I thought the comparison made sense. And Super Iron Bob points out quite reasonably, not just that, you have people calling for harm to people with the membership of that group. Yeah, exactly. We are specifically requiring you, the government is requiring you to identify yourself as the other, mandating it, and saying, basically in so many words, this is a disfavored group, a diseased group, right? It's a diseased group. And, that's kind of important because a sense of disgust is one of the principal things that separates right-leaning and left-leaning people. That's one of the major indicators of right-leaning versus left-leaning. And also, when you say, well, they're diseased, the next logical step is, well, they're not really people, and the next logical step, and the next logical step. So yeah, Hitler was a was definitely had disgust, and he didn't like the trash. He started his reign with, let's clean up all the factories and let's make them neat and tidy, and let's kill all the rodents and the vermin. And to do that, they used a chemical called Zyklon A. And then it was, oh look, these people are also vermin. They're also diseased. Let's eradicate them. Yeah. So there's that. It's a little bit suggestive of an authoritarian impulse that doesn't necessarily end very well. Mandatory quarantines for the diseased. Mandatory quarantines, so you have to stay in your home. You can't leave. You can't be part of society, right? You can't be part of society. Look at them. They're the diseased other. They're the diseased other. They're the reason that we can't return to normal. The diseased other. And here is an external symbol of them being the diseased other. Authoritarian, like separating families at the border and putting children in cages. Yeah, but who started that again? Who started the separating the children at the border and putting them in cages? Which administration started the separation policy? Which administration started the cages? Here's a hint. It wasn't the Trump administration. And also, is that policy continuing today? It was a settlement as a result with the lawsuit with California. Well, so what is my answer to that, right? A settlement is agreement. You can't settle unless both sides agree. So it's a result of a settlement. So what? What's your point? The government agreed to it. I don't know how that in any way contradicts my point. The government said, yeah, this policy is totally right with us. We're cool. I'm not sure how that undermines anything I said.